Hello and welcome back to EESC 315. This is Lecture 21, and today's topic is public participation in hearings. I'm going to focus mainly on public hearings and the way they've been done over the past few decades, focusing on the provincial-federal joint process. Now, a couple of disclaimers about that. First is if you're in a different jurisdiction or a single jurisdiction, they have some leeway to do things differently from what I've described. And the second is, a few weeks ago we had a guest lecture from Dr. Kevin Hanna, who described some very significant changes to both the provincial and federal environmental assessment processes. So that could affect this in a few ways. First of all, consultation is much more heavily loaded to the front end of the project, so that hopefully by the time a proponent gets to a hearing, they've addressed a lot of their stakeholders' concerns. So that should, in theory, simplify this process. The second is, of course, COVID. So presently COVID has forced all of these hearings to be online, and like almost everything else in the world, it's impossible to know what the world will look like once COVID is done, but it's safe to say that there will be a lot of processes that are permanently altered by COVID. So for example, just like online learning, just like this lecture that I'm giving today here on YouTube instead of standing in front of you in a classroom, I expect that hearings will be some sort of a hybrid moving forward, whereby some people will attend in person, some people will attend online. So of course there's great benefits and some drawbacks to that. So the benefits obviously are it's much more convenient, but on the flip side, I think that hearings are much better in person in the process I'm about to describe, to be able to look a person in the eye and to ask them questions and to get their response in person is just a much better process in my opinion. But like everything else on earth, we'll see how things return to normal. When they return to normal, it's pretty much impossible to even speculate on where we will be going. Another thing is I've put a lot of links in this video. To open the links, I've posted a PDF on Canvas which have live links. And lastly, I will just mention on the length of this process. So some of these hearings take extended periods, weeks, months, and in some cases, these hearings can be a day or a couple of days. So it really depends on the jurisdiction. It depends on the size of the project, the area that it will cover, and the proximity to people. So a lot of things vary here, but I'm going to really go over the general process. So with that, let's get into public participation and hearings. So looking at slide 2, these are some of the typical processes that are involved in the public participation of an environmental impact assessment. And these are roughly in order, but keep in mind, again, this can vary a lot. Proponents can be sent back to earlier steps, and we can go through multiple loops of any one of these sets of steps. So I'm just going to go through it as if this is a linear process. So starting with public notifications, then there are open houses by the proponent, which can happen before, during, or after the environmental impact assessment is being written. And then after submission of the environmental impact assessment, there will be written information requests, mainly by regulators, but also on behalf of directly affected parties. Once all of those are complete, the government will actually do something called deem the project complete in some jurisdictions. And at that point, the process gets turned over to a joint review panel. And a joint review panel is usually 3 people who are jointly nominated by the provincial and federal governments to recommend a decision to the decision maker, which is usually provincial and or federal ministers. So it's 3 people who have a lot of expertise, who are deemed to be very impartial, and who can digest all of this information on behalf of Canadians as a whole. Directly before the hearing, there can be written interventions by anybody who is directly or indirectly affected, and then finally written submissions to an online registry by the general public. And the last step is the public hearing, and that's usually the last step before either an approval and or a rejection. So we'll go through all of these one by one. Keep in mind this is not the last step in the EIA process. There's still the actual formal approval by the decision makers, followed by approval conditions, followed by follow-up monitoring, topics which we'll be talking about next week. Before I get into the details of these various aspects of public participation, I'll just mention that Virtually everything that I'll be talking about for the rest of this presentation will be captured by a proponent in consultation records. Generally, consultation records are submitted with an EIA, both at the time that an EIA is submitted in order to update regulators on consultation to date, and then it will also continue right up till the time of a hearing, and the joint review panel will like to see those consultation records as well, because public participation is a very important part of the process, and often it can be done in parallel with the EIA, and it can be both as voluminous and as important in terms of the final decision, in terms of how much consultation has been done, how well has it been done, but most importantly, has the proponent actually listened to people and made any modifications to their project, or at least accommodated people in terms of what they're looking for in these consultation records. On slide 3, you can see the links to BC Hydro's consultation records for Site C. These are all part of Volume 1. These are appendices, so G, H, and I, and we're showing the consultation records for general public, Aboriginals, and government agencies. And you should probably have a look inside these just to get a feel for how they're organized. Generally, this is a fairly typical way that proponents will do this. They'll have a table that lists the parties, the dates, the original concerns, and some sort of a follow-up response to show how they're being addressed. On slide 4, I'm showing the very basics of public notification. The first public notification is usually just some sort of a statement of intent, and this is where the proponent lets the public know that they're planning to start some project and that they're seeking input. They also need to notify the BCEAO, the Environmental Assessment Office, and that formally kicks off the whole EA process. Once the EAO and other government agencies have started collecting information, they will notify the general public themselves. They'll also put the onus on the proponent to notify the public, but the EAO will notify the public that there is a public comment period which is now open. And the public comment period is usually 30 or 60 days, depending on the process. And during that time, the government will directly seek input from the public. Another important part of the public notification process is that government agencies will generally provide funding to directly affected parties. And the term directly affected is a very important term because there is a test for whether a party is directly affected versus just some person who wants to provide input who might live 1,000 miles away but thinks they have a lot to say about the project. So directly affected people and parties can get funding from the government. In the end, the proponent will end up paying for all of that funding. After the hearing has ended, the joint review panel will look back at the hearing and the interventions, and they will make a determination about which directly affected parties have contributed to the hearing, and they will use some calculations to apply some sort of a funding rate whereby the proponent will pay back some or all of the funding for every party. And the last thing I'll mention on this slide is that if the proponent is applying for something which will affect a permit or anything else under the Environmental Management Act, then there is a specific regulation they need to follow, and failure to do so could jeopardize their approval. Going on to slide 5, I'll talk about open houses. And I do recall speaking about this in one of the earlier lectures, although I don't remember which lecture it was, and I'll try not to be too repetitive, but this is really a formal part of the process that I'm going to cover again, as it is a big part of public participation. And I think I mentioned last time that in my experience, open houses are by far the most effective way to communicate between the proponent and stakeholders. If they're done properly, which is to say, done in a way where there's a true conversation and not just one party standing up speaking at another party, this is a really good opportunity to understand stakeholders' concerns and to have really meaningful dialogue. So I've listed here the two big opportunities. Number one is the proponent's opportunity to speak directly to the public. That will almost certainly always happen. There will always be some sort of a presentation where the proponent will get up, go over the major details of the project. Particularly, it gives them a chance to talk about what the benefits might be. But it also gives the opportunity to hear directly from the public because the proponent then will usually have an open mic And in some cases, they'll have very informal sessions where the public can speak directly with company executives, technical experts, really anybody who's involved in the process. And the communication tends to be a lot more genuine and informative rather than a lot of the written information that I'm going to be talking about in the following slides, which tends to be filtered through many, many layers of management, lawyers, and lots of other people who like to be extremely careful about what they put on the written record, and in doing so tend to remove a lot of the meaning from the content. In some cases, the government will send representatives to also give a presentation, or at least just to record the proceedings so that they have a track of what are the main concerns. Often the people will like to hear directly from the government to understand how the government is representing the public's interests in the whole process. There will often be a number of open houses, typically one in each small community that is closest to the project, and then one or more in a larger community, which is not necessarily as close to the project, but something that can gather more regional interests. So in the case of BC Hydro, you can see in their consultation record, they had many, many public open houses. And that's appropriate for a project like that because certainly damming a large river like the Peace River and creating an 83-kilometer long reservoir is going to potentially impact a lot of different communities. And another thing that BC Hydro did, which was, in my opinion, very good and not always done, is that they did multiple rounds of consultation in the same communities. So they were able to listen to people, go back, and then tell people how they had addressed their concerns. And if a company has just gone into a community once, had an open house, maybe listened to a few comments, and then put something on the written record, when the stakeholders read that, they're going to almost certainly reject it and they'll go to complain to the decision makers that they were never listened to. And in fact, a lot of times they will appeal a decision in the courts and they will actually have grounds to do so. So not only is it good for stakeholders and it's good for the decision-making process, it really helps insulate the proponent against later lawsuits, which is a really big thing in EIA. On slide 6, I'm showing the next major step of public participation, which is written information requests. And this is typically done immediately following the submission of an EIA to the government. So the proponent will submit an EIA, the government will then post it online and sometimes distribute it, but often just put out a notification that says the EIA is online. Anybody who has an interest in this can send us some written comments and we will compile them and send them to the proponent. Or if it's a directly affected party, then that directly affected party will engage with the proponent. And the types of information that directly affected parties will seek from the proponent and the types of information that they'll provide to the government really varies. Sometimes they are highly sophisticated. They will hire expensive consultants who will do extremely thorough analyses and sometimes even redo parts of the EIA. But most of the time, the directly affected parties will stick to some basic facts about how they're being affected themselves, how the project can impinge upon their rights or their everyday life, and they will seek some sort of remedy. Sometimes it's mitigation, sometimes it's compensation, and fairly often they will also seek to have the project rejected outright. And having multiple parties seek to have a project rejected can make the decision making very difficult for the joint review panel and the ministers who need to make the decision, because often what we have is simply NIMBYism or not in my backyard. The reason that's a problem is because virtually everybody uses resources. Everybody relies on resource extraction, whether it's mining, oil and gas, or really any other type of resource extraction in their everyday lives. We all drive, we all have cell phones. However, virtually nobody wants to have heavy industry or mines or oil and gas extraction directly in their backyard. So this makes the job very difficult for the regulators because essentially they have to approve some projects or we don't have the type of standard of living that everybody wants. In other words, we don't have the tax paying jobs, we don't have the steel to make things, we don't have the energy to fuel our lives. And often the people who are opposing a project will argue, well, we think this is a good project, we just think it should be built somewhere else. But in my experience, I've never seen a project that nobody objected to. So trying to come up with some project somewhere else that nobody's going to object to is not even really a realistic proposition. And really, that is the whole crux of environmental impact assessment. But getting back on topic of the affected parties, a good example in the Site C of an affected party is Ken Boone and his wife Bonnie. Ken was a very vocal opponent of the project. I believe he was a local farmer whose land would either be flooded or adjacent to the flooding area, but he was a prolific writer. If you search his last name, you can see that there are 35 different documents back and forth between Ken, Regulators, BC Hydro. He also organized quite a large community uprising against Site C, and that's reflected in a lot of the documents that you'll see if you search his name. This is fairly typical of any large project. There will be one or two people who organize a lot of other people to write submissions, and the decision makers need to take all of that into account. And again, this is precisely the challenge with EIAs. How do you balance the needs of, say, 35 million people in Canada who need some power, need some resources? Perhaps need is not the right word, who basically demand these things from their government versus 15 or 20 or 30 or whatever the number is of people who are very, very adversely affected. Once again, I'll just mention, I think I've said this several times, but I am so glad I'm not the decision maker. That would be an extraordinarily difficult thing to have to do. So I'll move on to slide 7 and talk about the regulators. And this is much more straightforward. The regulators are usually split into their respective ministries. So the Ministry of Environment, Fisheries and Oceans, Transport Canada, Health Canada. Provincial ministries will also have each of their submissions. And this is often a very straightforward exercise. They each have their mandate. They have a very specific part of the EIA that they'll review. They have a very specific list of things that they're looking for. They want to see that everything within their domain is protected, and everything that can't be protected is either mitigated or compensated. Really, that the proponent has done the best available science to understand it and has done the best available practice in terms of mitigating it. And this isn't to say that regulators are perfect. Sometimes they do get political. Sometimes they tend to dwell on topics that reflect the pet topics of the reviewer. But for the most part, they're very straightforward and they have a mandate and they stick to it. And it's just up to the proponent to show how the proponent has done the best science and applied the best mitigations within that specific realm that the regulator is looking for. So again, I've put a few links here to different regulatory documents on the registry. You can have a look at these. You'll see that they're pretty straightforward, pretty well itemized, pretty factual, and that's kind of a straightforward part of the job. On slide 8, I've referred to some of the First Nations consultation, and this is where we again have quite a variety of different levels of review. So some First Nations are extraordinarily well organized and funded, and they hire large teams of consultants. Sometimes the team is just as big as or even bigger than the proponent's team, and they will tend to thoroughly examine every piece of the EIA and sometimes redo the EIA itself. And in some cases, they will have their own team completely redo the EIA, and then that becomes part of the evidentiary record for the review panel and the decision makers to consider. Now, what I've just referred to really only applies to First Nations where they've been dealing with the industry for a very long time. So, for example, any First Nations that are located near a mine that has been there for a long time or some other industry, and they've got long-standing relationships with both the mine and the community. They know the system very well, and they've got all of the resources they need to do this. And often these EIA reviews get turned into an ultimate lawsuit against the company. And the lawsuit's not so much on environmental grounds, but as it relates to enshrined First Nations rights. As a technical practitioner, it can get very difficult to try and respond to these because the nation will assert rights related to hunting, fishing, and trapping, which can be affected in a very small way by some technical aspect, whether it's a very slight change in a water concentration or something that is technically a change, but something that we would typically not consider an effect, particularly not a significant adverse effect, as we talked a lot about in the previous lecture. This becomes a very difficult technical issue to navigate, especially considering that a lot of times these are building up to a lawsuit, which goes way outside of the scope of our technical expertise. So that's kind of the second category. And then the third category of First Nations are those that really are not well sophisticated and not well funded. So these are often nations that are quite far from industry, haven't dealt with industry much, and don't know how to navigate the system. And they will tend to refer a lot more to some sort of general aspects of the project without getting into much technical details. And in this case, it often comes down to the proponent being able to mitigate and to be able to work with them to resolve the issues without getting into huge amounts of technical detail. And in some cases, the joint review panel will note that the topics are really getting out of the realm of the environment and into enshrined rights under the Constitution and under the Indian Act, and they'll tend to take that offline and separate it from the EIA process. And at that point, it's really just a legal issue that the lawyers will try and resolve one way or another. Now, moving on to slide 9, I'll talk about the last category of submissions, and this is submissions by the general public. And these really take one of two forms. Either people strongly opposed to the project, and this is often people who really have nothing to do with the project, otherwise they would have been listed already in the directly affected category, and people who are strongly in support of the project. This tends to be people who might get some benefit from the project, such as trade unions who are speaking on behalf of several hundred people looking for a job, or a chamber of commerce who are looking for the spin-off benefits. Local businesses often also are looking for spin-off benefits, and you get the odd unemployed person really hoping to convince the decision makers that the project should go ahead. But of course, none of these people are listed as directly affected. And to be honest, I don't know if the decision makers take any of this into account whatsoever. And the reason I say that is because I've never seen it reflected in a decision report, nor in any statements by a joint review panel, or in any of the decision makers' actual reasons for a decision. So it's really unclear to me what, if any, effect these comments have on the decision makers. So after all of these comments have been received and processed by the government, there will be a lot of back and forth, and there can be multiple rounds of these. We then move on to the questions from the joint review panel, and I've put a couple of comments on those on slide 10. So what I've said here is that these are by far the most serious questions for a proponent, because when the joint review panel is asking the proponent questions, the proponent knows that this is really serious. They need to answer these questions, and they need to answer these questions very thoroughly, because the joint review panel only asks a question if they reviewed everything on the record and they think there's some source of uncertainty or something that hasn't been covered or some piece of information that would prevent them from making a sound decision. So when the joint review panel asks a round of questions, and usually they'll ask anywhere from 10 to 20 questions, the proponent will put all hands on deck to answer these as quickly and as thoroughly as possible. And I hadn't mentioned this earlier, but each of the previous rounds of questions that I've talked about are typically anywhere from several hundred to a few thousand questions. So the regulators and directly affected parties, First Nations consultants, they'll tend to write long documents with many, many, many questions. The joint review panel, on the other hand, will write just a very few absolutely critical questions that are directly going to affect any sort of decision they make. Once the information gathering portion of this process is complete, it's time for a public hearing. And a public hearing can vary. It can be a day for a small project, it can be a couple of months for a large project like a mine or a hydroelectric reservoir. And in some cases, like these pipelines that have been in the news for the past 5 years or so, the hearings can last seemingly forever. Usually, the bulk of the hearing is in a larger city that is relatively close to the project. And the reason for this is because they need to have accommodations, transport, a venue. There's a lot of big logistics that go into one of these hearings. And so, necessarily, these are located in cities. However, it's quite common that the hearing will be moved to a small town for a day here and a day there to get the views of the local people and to help the local people be more involved. And it's not that they can't go to the city, it's really just about showing respect, I believe, and showing that the whole review panel, technical teams, government care enough to actually visit the towns that are going to be affected. So at the start of the hearing, all of the previous information that is on the public record now becomes evidence. And the hearing is a quasi judicial process, meaning that virtually all the same rules that apply in a courtroom apply in the hearing. Really, the only difference is that it is not adjudicated by a judge, it's adjudicated by three panel members who are nominated, although they follow almost the same rules as any courtroom and the same type of procedures as judges, and they're treated with the same level of deference. For example, everybody stands when they walk into the room, but it is technically not a judicial process. Now, one interesting thing about public hearings is that technical experts are almost always completely excluded from speaking one at another. And the reason is because nobody benefits when two technical experts start getting into some highly technical conversation that nobody else understands or cares about and usually has absolutely no bearing on the big picture. This is just showing a typical layout of a hearing, and I'll just go through this bit by bit. At the far left, you see the general public and seating area. So these are always open to the public, which is good. The general public can come and attend the entire hearing, although in very few hearings do the general public have the opportunity to get up and speak to the joint review panel. Only directly affected people and regulators have that opportunity. You see a person in red there standing at a podium. So basically, one person will be speaking at a time, and that person can be speaking directly to the company's representatives and their panel of experts. And so that's what these red arrows signify. That's who's speaking and who they're speaking to. Now, what's interesting about the joint review panel process is that as an expert, you don't actually answer the person who asked you the question. You listen to the question, you turn, and you speak to the joint review panel because the entire process is geared towards getting those three people the information they need. At this point, you have no interest whatsoever in answering the person who's actually asking the question. That's not what the hearing is for. It's purely so that that person can ask a question and have the answer be delivered to the joint review panel. So, in this process, each team or each set of parties, the proponent being the first party, sits as a panel of experts, and every other party takes turns asking them questions. And again, the answer goes directly to the review panel. And then the government staff will have a round of questions for the experts, and then the joint review panel themselves will ask a round of questions, and each answer goes back to the joint review panel. Once the proponent is finished answering questions, then the next party who is registered, which is often the government, will then take a stand and everybody asks them questions. And in this way, everybody's evidence gets tested. In other words, all the experts, including the reviewers, have to defend their position technically in front of the joint review panel so that the joint review panel can judge for themselves what is credible, what is not, what evidence should they consider, and what evidence should they discard, just like a court case. Now, a couple of other things I'll add. You can see the headphones, that is signifying a court reporter or a stenographer. So everything that is said either by the person asking the question or the expert witnesses or the joint review panel themselves. That gets recorded on an official transcript, which again is basically a legal document. So if you are under oath, everything you're saying is now part of an official record. Accompanying the court reporter is often a translator. And so keep this in mind if you find yourself giving expert testimony in some highly technical session, particularly in the Northwest Territories. The translator will be translating into one or more local Indigenous language. There can also be French to English, of course, or vice versa in Canada, being a federal process. But the more challenging aspect of this would be trying to translate your technical language, whether that's about a model coefficient or a biological process or a geological formation or what have you, into an Indigenous language, and often the translator is not a highly technical person themselves. So you are continually being asked to slow down and back up as a technical expert if you're not keeping this in mind. And so while I said earlier that your language here and your answers are intended to support the joint review panel, and ultimately they're the decision maker or the decision supporter in this process, you also need to keep in mind that this is a public participation process and that you need to speak in a way that the general public can understand you. And more importantly, in some cases, the translator can keep up and convey that into local languages. So this is definitely a difficult position. I have a lot of sympathy and respect for these people, and we need to do our best to accommodate them and to help them do their job in the process, which is to convey our technical language and to convey the information that we need to the public who is intently listening. There's a little webcam shown there. This is a newer feature. A lot of the hearings these days are actually webcasted, so you can watch from any place on earth. The format I just laid out is the common way of doing things or the historical way of doing things. But of course, these days, and by these days I mean the year 2021, I'm recording this lecture on April 1st, 2021. So these days, all of these hearings are being held by Zoom calls, which is highly impersonal and not a conducive format for public participation, of course. And hopefully, one of the things that will return back to normal soon will be the resumption of in-person public participation hearings. So that is it for public participation and hearings. Like a lot of the things that we've covered in this course, there's more to it than what I've talked about, but I think that gives you a good flavor for how the public is engaged, how proponents need to answer their questions, and how it all gets absorbed by the decision makers. So I hope you found that somewhat interesting. Have a great couple of days, and we'll see you in the next lecture, which will be about decisions and follow-up. And following that, we have one lecture on ethics, and that will conclude our semester.